5 legal mistakes gun owners make that can lead to arrest. Most gun owners train for marksmanship. Some prepare for self-defense scenarios. But very few are taught how the law actually works once a firearm is involved. And that's where the real danger begins. Across the country, responsible citizens are facing criminal charges. Not because they broke the law intentionally, but because they misunderstood how it's enforced. A simple traffic stop, a poorly chosen word, or mistaken assumption about your rights can escalate into a life-altering situation. In this episode, we're unpacking 5 of the most common legal traps that catch even well-trained gun owners off guard with real cases, critical lessons, and clear steps to protect yourself and your rights. Before we get started, please subscribe to our channel and let's get started. Trick number 1. You can use your gun. Anytime you feel threatened, it sounds logical. If you're scared, you act. But the law doesn't care how you feel. It cares whether you were in real imminent danger and whether your response was reasonable. Here's what actually matters. Self-defense laws require threat to be immediate and unavoidable. Feeling fear is not enough. You must be able to explain what the threat was. Courts ask, would a reasonable person in your shoes do the same thing? Prosecutors will dissect your every move. If your fear seems vague or exaggerated, they can charge you. Real case. Example, in 2022, a man in Arizona pulled his concealed pistol on someone during a road rage confrontation. He said he felt threatened, but dashcam footage showed no weapon, no aggressive movement, just shouting. He was arrested for aggravated assault with a deadly weapon and lost his concealed carry rights. Bottom line, don't rely on emotion. Train yourself to look for actual danger. Weapon present, threat advancing, no clear exit. And learn how to describe that threat clearly and legally if it comes to that. Trick number 2. Castle Doctrine means I can shoot anyone on my property. Castle Doctrine is one of the most misunderstood laws in the self-defense world. It does give you special rights in your home, but that protection is not unlimited. Here's what you need to know. Castle Doctrine typically applies inside your home, not your porch or driveway. You usually must prove unlawful entry, not just someone being on your property. Lethal force must still be reasonable under the circumstances. If someone is fleeing or unarmed, Castle Doctrine may not protect you. Real case example. In 2021, a homeowner in Missouri shot a man rummaging through his car in the driveway. The intruder ran when confronted, but the homeowner fired anyway. He was charged because the man was retreating, and the car wasn't considered part of the home under state law. Key point. Castle Doctrine isn't a license to shoot anyone who steps on your land. You still need to show they posed a real threat or that they were trying to enter your home unlawfully. Trick number 3. If it's legal to carry here, I'm covered everywhere. One of the biggest mistakes gun owners make is assuming their rights travel with them. Unfortunately, gun laws don't work like a driver's license. Crossing a state line can turn you into a felon. Here's why this is dangerous. Each state sets its own firearm laws, especially for concealed carry. Reciprocity agreements vary. Some states recognize out-of-state permits, others do not. What's legal in your state may be completely banned in another. Even transporting your gun across state lines can be a crime if not done precisely. Real case example. Shainene Allen, a single mother from Pennsylvania, was pulled over in New Jersey with her legally registered handgun. She volunteered the information thinking she was doing the right thing, but her permit meant nothing in New Jersey. She was arrested, charged with a felony, and faced years in prison before finally receiving a pardon. Lesson: always research local laws before traveling with a firearm, especially in states known for strict gun control. One wrong turn and your life could change overnight. Trick number 4. Nervous? That's the setup. This is one of the most subtle but effective tactics used during traffic stops. It sounds casual, even routine, but it's packed with legal weight. An officer may say something like, "You're acting nervous." That gives me reason to believe something's wrong. And just like that, they escalate the stop. Here's what's really going on behind the scenes. Officers often use subjective phrases like nervous behavior, shaky hands, or avoiding eye contact to claim reasonable suspicion. But courts have repeatedly ruled that nervousness alone is not enough to justify a search. The problem is that most drivers don't know this and they don't challenge the officer's logic. When people hear an authority figure say, "You're acting suspicious," they freeze, comply, or start justifying themselves, which can actually give more ammo to the officer's suspicions. What you need to know: being nervous during a stop is normal. In fact, courts have acknowledged that almost anyone would be nervous if pulled over, especially while carrying a firearm legally. Nervousness is not a crime, and it is not probable cause. But if you don't understand that, or if you start talking too much to prove you're harmless, you might walk straight into a search or even a charge. What to do instead? Stay calm, speak clearly, and don't justify your emotions. Do not say things like, "Sorry, I'm just nervous." That's ammunition for their report. Stick to your rights. Provide ID, firearm license if required, and then remain respectfully silent beyond that. If they say they're going to search based on your nervous behavior, calmly respond, "Officer, I do not consent to any searches." And then stop talking. Let your lawyer handle everything else. Trick number 5, the fake command. This one's dangerous, and courts have upheld it if you don't push back the right way. An officer walks up, maybe after a few minutes of routine questioning, and says, "Okay, I'm going to search your vehicle now." Notice the wording. They didn't ask. They didn't say, "Can I search?" They just declared it as if it's already happening, and most people assume they have to comply. Here's why this works so well for them. The statement is designed to make you feel like you have no choice. If you respond with silence, nod, unlock the door, or even step aside, the court may interpret it as voluntary consent. And once you've consented, any evidence they find can legally be used against you, even if you never actually said yes. Real case law supports this. Courts have ruled that actions like unlocking a door, opening a trunk, or stepping back from the vehicle may count as implied consent, even when no verbal permission is given. How to respond: don't argue, don't get physical, and never resist. But you do need to speak clearly and on record. Say, "I do not consent to any searches." Say it once, say it firmly, then stop talking and remain non-confrontational. If they search anyway, your statement sets the stage for your attorney to challenge it later. But if you say nothing or worse, silently comply, you may have just given up your strongest legal defense without even realizing it. Trick number 6. It's just a warning shot won't save you. A lot of gun owners believe that firing a warning shot is a safer, more responsible way to handle a threat. But in the eyes of the law, that single round could be the thing that lands you in jail, even if no one gets hurt. Here's what the law actually says. Firing a gun, even into the air or ground, is considered use of deadly force. If there was no immediate life-threatening danger, that force is unjustified. Prosecutors may charge it as aggravated assault, reckless endangerment, or unlawful discharge depending on your state. Trying to scare them is not a legal defense if the threat wasn't imminent or specific. Real case example. In 2010, a Florida woman named Marissa Alexander fired a warning shot into the wall of her home during a domestic dispute. No one was injured, and she claimed self-defense under Florida's Stand Your Ground law. But because the jury found there was no immediate threat when she fired, she was sentenced to 20 years under Florida's mandatory minimum laws for aggravated assault with a firearm. Eventually, public pressure led to a retrial and reduced sentence, but not before she spent years behind bars. Bottom line, pulling the trigger for any reason must be legally justified. Warning shots might feel like a compromise, but in most cases, the law treats them the same as shooting at a person. Unless your life is in immediate danger, keep your finger off the trigger, or you may end up defending your actions in court, not your home. Know the law or risk everything. You don't carry a firearm because it's convenient. You carry because you're willing to defend what matters most. But the legal system doesn't care about good intentions. It cares about facts, procedures, and technicalities. Let's review the 5 tricks again. Feeling threatened isn't enough. You need a clear, justifiable threat. Castle Doctrine isn't unlimited. Your home has limits under the law. Your carry permit doesn't cross state lines. One trip can mean a felony. Remaining silent requires words. Invoke your rights clearly. Police are not your defense team. Don't give them evidence to use. Every one of these myths has sent real gun owners into real legal nightmares, and you don't want to be next. Stay prepared, stay smart, and stay legal. We'll keep fighting to keep you informed.